Good morning, everybody. This is Sadhvi Bengeri from BBA LLB Honors, first SEM, here to present my presentation on dowry debts, issues, and challenges. Indians in particular are obsessed about three things in their life. The first is cricket, the second is food, and the third is any guesses? Yes, it's marriage. It's marriage. Indians are obsessed with marriage. If you know, the preparations for marriages begin from the day you're born. Especially if you're a girl, the collection for your dowry begins from the day you're born. A girl is raised, educated, embraced by her parents only to marry her off, abiding by the societal rules in the hope that she'll find a better bridegroom. The parents agree to give dowry. And later, they end up finding that their daughter, the newly wedded bride, is subjected to harassment and, in some cases, their daughters being killed. So this is a very disheartening issue in the 21st century to be talking about dowry debts again and again, despite of several provisions made by the legislations. In my presentation, I look up to why dowry debt is still prevalent in the society and the challenges we as a society have to face to eradicate this social evil. So my presentation goes like, the contents of my presentation today are understanding dowry and dowry debts, provisions for dowry debts, the gravity of the problem, and changing the cultural attitude, which is especially a challenge in society like India. So dowry is a payment such as property or money paid by the bride's family to the groom or his family at the time of marriage. One theory claims that concept of dowry began as kanyadan or stridhan, where Hindu families used to donate something of value to their daughters. This was because the tradition of that time didn't give any property of the fathers to the woman, to the daughter. So, in absence of such legal rights, Kanyadana was very popular, and dowry was offered as a compensation for it. But now the term dowry has taken a different meaning. In the past, something of value was given to the bride, to the daughter, but now it is given to her greedy husband and in-laws. The accepted credo is that it is because dowry has been paid by the girl's parents at the time of her marriage, shows that the girl is considered a liability by her own parents, so that she would be transferred as soon as possible to another household. In certain cases, the payment of dowry is so large that they have to take in loans. And such large dowries also make the girl's family reluctant to accept her back when she is ill-treated in her marital home. This leads to further increase in this social evil practice. There are many provisions made by a government. One such provision includes Dowry Prohibition Act 1961. Dowry Prohibition Act 1961 defines dowry as any property or valuable security given or agreed to be given either directly or indirectly by one party or to a marriage to another, or by the parents of either party to a marriage or any other person to either party to the marriage or any other person at or before or any time after the marriage in connection with the marriage of the said parties, but does not include dower or meher in the case of persons to whom Muslim personal law, that is Shariat, applies. The one wide range of definition that it occurs is that dowry could be asked at, before, or any time after marriage. In the recent case in January 11th, 2022, state of Madhya Pradesh versus Jogesh, the Supreme Court noted that the context of dowry ought to be ascribed an expansive meaning so as to encompass any demand made on a woman, whether in respect of a property or a valuable security of any nature. When dealing with cases under IPC section 304, the shift in the approach of the court ought to be from strict to liberal, from constricted to dilated. Any rigid meaning would tend to bring not the real subject of the provision. The another significant subsection that this provided was penalty for taking dowry. So under this act, penalty for taking dowry is imprisonment for 5 years, and the fine which shall not be less than 15,000 rupees. The court might change making it fewer or lesser, and also has the ability to give life imprisonment as a punishment. Penalty for demanding dowry is also a punishable offense under this act, which the punishment would be imprisonment for not less than 6 months, which could extend to 2 years, and fine that may extend to 10,000 rupees. Another very significant and paramount importance of this act is that it provides the appointment of dowry prohibition officers. Dowry prohibition officers were appointed, like said to be appointed by the state themselves, and they are given certain exercise and performance to perform the following powers and functions. That is, to see the provisions of this act are complied with, to prevent as far as possible the taking or abetting to taking of the demanding of dowry, to collect such evidence as may be necessary for the prosecution of persons committing offense under this act, to perform such additional functions as may be assigned to him by the state government or may be specified rules made under this act. This power was decentralized by the central government to ensure that this social evil is eradicated. The anxiety of the government is visible through the provisions of this act. Marriages are made in heaven. A bride leaves her parental home for matrimonial home, leaving behind her sweet memories, with the hope that she will see a new world full of love in her groom's house. She leaves behind not only her memories, but also her surname, gotra, and maidenhood. She expects not only to be the daughter-in-law. The rise in the number of cases involving harassment of newly wedded girls for dowry shatters the dream. In-laws are characterized to be outlaws for perpetrating cruelty which destroys the matrimonial home. The killer is dowry, and it is spreading its tentacles in every possible direction. Recorded the Supreme Court in Kamlesh Panjiyar versus State of Bihar. But this kind of news headlines do not fail to make headlines. This kind of news does not fail to make headlines. A retired High Court judge who has been booked for assaulting his daughter-in-law over dowry. At least we do not expect this from the jurists of this nation. Those people who sit and make laws for us have been involved in such practices only shows that educated class in this country still tends to follow these evil practices. In this case, the daughter-in-law was brave enough to bring up the plight of her house in the society. In many cases, the brides have no guts to bring the news or the ambience of her house to the society, and suffers the harassment in silence, and in turn it leads to her death, either by burning or by abetting to suicide. So dowry deaths, it brings me to dowry deaths. Dowry deaths as an offense was inserted in IPC other abnormal circumstances within 7 years of marriage, and it must be shown that she had been subjected to this cruelty or harassment prior to her death by the husband or his family in connection with dowry. Essentials of dowry deaths are: it should be a death of a woman, it should be within 7 years of marriage, she should be subjected to cruelty by her by husband or his family prior to her death. Such harassment or cruelty should be in the connection to dowry. Several provisions that are present in the Constitution and IPC. One of them is Article 21, right to life and liberty. The in-laws or the husband not only take her life and subject her to cruelty all throughout her life, but they also take her right to life and liberty by constantly harassing her and subjecting her to cruel deeds like suicide. And Section 304B of IPC. Section 30B of IPC came into effect by Criminal Law Amendment Act in 1986. The cause for this enactment was the failure of Dowry Prohibition Act in 1961. The essentials in this section to be considered as a dowry death is: the death of woman should be caused by burns or bodily injury or otherwise than under normal circumstances. Such death should have occurred within 7 years of her marriage. She must have been subjected to cruelty or harassment by her husband or any other relative of her husband. Such cruelty and harassment should be for or in connection with demand of dowry, noted in code noted in Shanti versus State of Haryana, AIR 1991 SC. It is a must that cruelty should have been caused soon before her death of a woman. Court noted in Keshav Chandra Panda versus State, 1995. The punishment under 30B of IPC is the punishment which is minimum 7 years of imprisonment and can be extended to life imprisonment. Section 113B of Evidence Act also provides a presumption as to dowry death. Soon before her death, the woman was to be subjected by such a person to cruelty or harassment for or in connection with any demand for dowry. The court shall presume that such person had caused the dowry. The nature of offense for dowry deaths is that it is a bailable offense. It is a cognizable offense, that is, the police does not need a court warrant to arrest. It is a non-compoundable offense, that means the court cannot be settled outside the courts, and it is tried by the session court as well. The gravity of problem. Such headlines have been making constant appearances in past decades. It has been 5 decades since the implementation of Dowry Prohibition Act 1961. Last year, we marked the 60th anniversary of appointment of Dowry Prohibition Act 1961. And this shows that the provisions made by the government, the legislative reliefs were made by the government, have been proved to be an utter failure. This is the graph that shows the suicide attempts by housewives in India. It is visible that in the marriage related issues, the major reason for this for the suicide among the married women in India is dowry related issue. An NGO worker from Vibhishna said that 50% of deaths or suicide attempts in India could be related to dowry, because it is a matter of shame for both a girl and her in-laws. These kind of news find it difficult to make it to the police. Proportion of marriages with dowry, we expect that dowry must have eradicated with the prevalent increase in education and literacy rate. But this graph, a research done by Gaurav and Chiplunkar, shows that proportion of marriages with dowry is increasing. So we can say that dowry is now prevalent more than it was in 1930s. There could be many reasons for this. One of them is the notion that giving dowry would probably give you a good bridegroom, a good household. Earlier times, the concept of dowry was only prevalent among the high class Hindus. But in the times to come, this has been taken up. The practice of dowry has been taken up by all the sections, all the caste, all the religion of this nation, and the dowry surpasses all the geographical locations in this nation as well. Nalini Singh, an NGO worker, shows that a dowry death is a light that women's shows the light of women's low political status. She clearly states that women hold zero political status, and denial of basic civil rights is the main cause behind the offense. A person perceives woman to be a weaker class or gender and subjects her to cruelty or harassment. The unnecessary authoritative attitude of husband towards their wife is the major reason for the dowry deaths as well. The status symbol is the another paramount reason for why dowry keeps on increasing year by year. More dowry, happier the marriage, which is a wrong ideology. If the demand for the desired dowry is not fulfilled, then there is no need for the wife to be alive, is the notion of the in-laws. These greedy in-laws only perceive the bride as a business deal, which is so wrong. It was absolutely stunning to witness in the month of July in 2020, 3 dowry deaths in a literate state of Kerala being recorded. It showed that the social fabrications have still safeguarded this evil practice, and this tends to continue to take lives of educated women. One such sad story is of the woman in the middle, that is Jyoti Shri. Jyoti Shri was married and was subjected to dowry harassment by her mother-in-law. Despite of her telling her parents about the harassment that she faced, her parents and her in-laws settled the matter in the house. And when she returned back from her maiden house to her matrimonial house, her mother-in-law locked her up in the room and switched off all the lights and the fans, didn't give her food or water. That caused her to take her life. So this is how the systematic acceptance of social evil is still prevalent. We should be in shame that being a literate class, we are still taking dowry. This brings me to changing cultural attitude, a challenge. Despite parents knowing that their kids are being girls are being harassed for dowry or dowry related issue, they still keep mum. And this shows that there is something very wrong in the cultural attitude. and changing it is a challenge that we as a society have to face. The first step towards a more effective legal response to dowry murders are arguably changing the cultural acceptance and attitudes surrounding the tradition of dowry giving. There must be a change in the notion at a woman that a woman is not a burden to her in-laws, and that this burden can only be relieved through dowry payments. With the currently inadequate state of legal responses to the murder of one's wife, there is nothing to indicate that any legal sanctions would prevent history from repeating itself. Because complete removal of the dowry practice will be met with immense resistance. The more effective way to combat this resistance is changing the social belief that a woman's worth is measured by dowry and she can bring to her husband. Effective removal of dowry tradition in India requires a social movement that provides the Indian community with a greater knowledge about horrors of dowry. The cultural and social patterns of men and women must be reshaped to acknowledge females' value in the society. If Indian society were to treat women as human beings and not merely as commodities to be exchanged for dowry, or dowry related harassments and violence would cease. The only thing I would end up to say is, once a woman knows that her worth is more than money and she says कि मुझे क्या बेचेगा रुपया, that is when the notion of dowry would change in the society. Thank you.